Hi, I'm Susan Tierney. This is Scott Horne, and we're back with Ask the Attorney and some more questions. So Scott, I hear a lot about land trusts and trusts. First of all, what's the difference between a real trust and a land trust?
Well, a land trust is typically set up to hold land, just like the name indicates. Typically, a legitimate trust, inter vivos, living trust, revocable, irrevocable trust, whatever it might be. First and foremost, oftentimes they have a tax ID number associated with it. They file their own tax ID number. Where with a land trust, so often the tax return is filed under the beneficiary's Social Security number or tax ID number. So it's handled a little bit differently in that regard.
Okay.
But typically a land trust is there to hold land or real estate of some type.
Okay, what's this I hear about a PAC trust?
Well, a PAC trust is a trust that incorporates multiple parties into it as the beneficiary.
Okay.
And there are some guys who espouse that this is the way to handle trust to get around due on sale. And we'll talk in a moment about whether a land trust gets you around due on sale or not and what to think about in that regard. But with a PAC trust, what you oftentimes are doing is you're incorporating the seller, yourself as the investor, and maybe a back-end home buyer even, into this one trust arrangement.
Okay.
And I just think there's some issues that are generated with that, unfortunately.
Okay, so tell me, why do so many investors feel that you have to close a sub-2 transaction with a trust?
So probably the most prevalent thing that I hear, at least, is a lot of people say they want anonymity. And to that, I ask, why?
Right. From what?
And they're going, well, I don't want anybody to know what I own. Well, what if I get sued? And of course, my response is I've been doing this for a very long time. I have done more deals than pretty much anybody I've met before out there. And I have never once worried about anonymity. My philosophy is really simple. If you do things the right way, and you take care of people, you don't need to hide from things. Sure, put your assets into corporate entities for protection, whether it's LLCs, corporations, limited partnerships, or any and all variations thereof for asset protection. But I just don't necessarily know the need for anonymity, because if you do get involved in a lawsuit, trust me, guys, the attorneys are going to find your assets through depositions, interrogatories, what it might be, and you're going to have to do that. And if someone has a strong enough interest to pursue you, the mere fact they can't find anything in deed records doesn't mean they're not going to file a lawsuit. So I don't see that as a very good excuse. And sometimes I just think that utilizing a land trust just overcomplicates the transactions a little bit.
Okay. So basically they don't really understand.
No, they don't understand it. And one of the things I really want to point out is so often it's not the seller who is creating their own land trust. The investor is creating a land trust for the seller. And then usually they do an assignment of the beneficial interest after closing. But when you're doing that, you're setting up a trust, which is a legal document. It can also be construed as a financial planning document of some sort. Okay. And then in my mind, I'm going, is the investor inserting themselves into the transaction as an attorney or maybe a certified financial planner? And are they, practicing law without a license or something like this? So I think those are real possibilities in those instances. So I just want everybody to understand that and be cautious. And if you are going to do those, bring in the right people to handle the paperwork for you. Don't try to do it yourself, just as a protection mechanism that's out there.
Okay. I got a question for you on a trust. If you're getting a tax ID number on a trust, are you paying taxes on the money you have in your trust?
Well, yeah. I mean, it's taxable like any other entity.
Okay.
Because it's once you have that tax ID number and you're filing your own tax returns every year.
Okay.
It's just like any other corporate entity to a certain extent, and then income generated by a trust becomes taxable.
Okay.
And it's not a tax shelter like maybe a Roth IRA or something of that nature that is out there.
Okay.
So just one more part about land trusts. in the owner finance world, again, a lot of people think that a land trust becomes some type of a financial planning trust. And of course, my question is what was the intent by the seller when they set it up? Was it really for financial planning purposes, or was it to sell the property and attempt to circumvent the due on sale clause, right? Putting a property into a land trust does not circumvent due on sale. In fact, it's a violation of due on sale day one. Then, if you're going to do a wraparound loan to a back-end buyer, that wraparound transaction is a violation of due on sale. If so, why do you want to put this land trust into the middle of the transaction when it's not needed? I simply don't see the mechanism for that out there. So be smart as you're thinking through your transactions a little bit and think through how to set your deal up properly. I like to use a land trust as a stopgap, per se, that if a due on sale violation occurs and the lender calls it due, the first thing I try to do is talk to the lender about Garden St. Germain or their attorneys. And so often they don't know what that is. And of course, that's an act where a homeowner can transfer their property into a financial planning trust and not violate due on sale. So as I said earlier, though, the land trust, when it was originally originated, was never set up as a financial planning trust. And if you ever get into a lawsuit on this, these mortgage companies have a lot more horsepower than we small investors do. They can bring in a lot more high-powered attorneys to solve that problem they want to. But I guess the last part of that is if you're going to buy a home and your intent is to lease the property long-term and not do a wraparound, or your intent is to sell the home under some retail format. In those cases, I don't have an objection to using a land trust, but let an attorney set it up so you don't get involved, so someone can answer questions on behalf of the seller if they're asked. And then, even though you may take an assignment of the beneficial interest, the great odds are that the lender won't know that occurred. And since you're just leasing the home, I think that might be a good system in that instance. So it's knowing when to use a land trust, I think, is all important.
And keep it simple.
Keep it simple.
Stupid.
Yes, ma'am.
I wasn't calling you stupid.
Thank you.
Okay. Okay, Scott, we get lots of questions about foreclosures. You every day get phone calls about it. But what is the standard foreclosure process here in Texas? You're licensed here in the state of Texas. So tell us, is it the foreclosure of a wrap or a sub-2 loan any different in a foreclosure?
No, and everybody thinks for some reason there's a difference. Now, as you said, Susan, I can only talk about foreclosures here in Texas. Other states may have very different laws or time frames that are involved. I know for a fact there are many states that have long, drawn-out processes. But since Texas was founded by robbers and thieves way back in the 1800s, they set our laws up correctly. They were probably all attorneys, obviously. But to start off with, we have to know what type of a property we're foreclosing on. So let's talk about a homestead. So maybe someone bought a home and it's their homestead through a subject to type transaction. And in that instance, I am hoping that that buyer gave the seller back a deed of trust of some type. Or if there's a wraparound mortgage, then there should obviously be a deed of trust. Now, of course, I see a lot of transactions where an investor takes only a deed to the property. There's not even what's called a vendor's lien in the deed and no deed of trust. And if you've done that, guys, and there's a default, that seller has one recourse, which is to retain an attorney to file a lawsuit. Our goal is to keep attorneys out of the transactions whenever possible. That's why we always recommend giving your seller a deed of trust to protect them. And that's a traditional mechanism to regain the house, i.e. foreclosure. So basically, if you have a homestead property, doesn't matter how they bought the home, with a subject to transaction or a wraparound, first and foremost, I tell everybody, read your documents. Know what they say. What type of a notice must you give them? Here in Texas, most of our deeds of trust at least say as per the Texas Property Code.
Okay.
In that instance, that would be a 20-day notice to cure the default. So once they receive that 20-day notice, they have 20 days to pay all the back payments current.
Not the whole amount?
Not the whole amount.
Okay.
Now, there's a lot of deeds of trust that are totally silent. If that's the case, it's going to be the property code most likely. But I also see deeds of trust that say you have to give the borrower a 30-day notice out there. In fact, I'm dealing with one of those right now. And I don't know why you want to give them more time if you don't have to.
Right.
And that's typically how a Fannie Mae, Freddie Mac type loan is set up.
Right.
So once that 20-day notice has expired, of course, we have to send them notice to cure with enough data in there. Fair Debt Collection Act notices and things of that nature go into the notices we mail out. We mail them out by certified and regular mail, and they have 20 days basically from the time they've been mailed out in which to pay. Now, during this process, of course, if they haven't paid, I always suggest that clients take the time and try to call your client and see what's going on. Maybe they need a little bit of help. Maybe they need a little bit of a workout plan, but it's worth taking the time to make a phone call, right? But
Before you're sending the notice?
no, after notice has been sent.
Okay.
Always be proactive. Always be fair but firm.
Okay.
And don't let people give you lip service. I have learned over thousands and thousands and thousands of residents and tenants that talk is cheap. Actions are all that matter out there. So do the right thing, then work a deal out after you started the clock running.
Okay.
So once that clock has run and they haven't performed, let's say they're out there playing ostrich, not doing anything,
Right.
or they keep telling you they're going to send a check in and they don't, the next step is called acceleration. And that is now where we accelerate the promissory note, which means now the entire amount is due, not just the unpaid principal and interest,
Right.
but now
The whole thing.
the monthly payments plus all unpaid principal.
Okay.
Now, here in Texas, we have to send that out at least 21 days before the first Tuesday of the month. So guys, if you're doing the math, look at a calendar, find the first Tuesday of the month, and Monday is the first day, and count back at least 21 days, and that is the last day, the drop dead date, that you can have your acceleration notice sent out by certified and regular mail, and it's the last day that you have to post it down at the county courthouse as well.
Yes.
So we try to do that.
We know this well because we are always at the last day running down there posting stuff.
We are. But the key is try to do it before the last day so it doesn't stress everybody out. And don't miss it by one day, because if you miss it by one day,
You have to wait a whole nother month.
you just lost a whole month again.
Wow.
And that costs a lot of money for clients not paying. So be smart, guys there in that instance. And
Now, what about a deed in lieu of foreclosure?
well,
Can you get that after you've given them the 20-day notice?
absolutely. You can get that anytime.
Or even after you've posted for the acceleration?
But here's what we do as a law firm, at least. And in this sense, we're talking from a legal perspective about this. Before we accelerate the loan, we are going to pull a title search on the property. And what we're looking for are any judgments that may have been filed or liens that might exist against the borrower in the property. Specifically an IRS tax lien or a federal tax lien, FTL for short. Because if there is a federal tax lien on the property, we must give the IRS a statutory 25-day notice in order to extinguish the IRS lien. If we don't do that, then their lien would become primary on the property. So we want to make sure we check.
I don't know why I thought it was 120 days.
That's a redemption period you're thinking about.
Oh, okay.
So we want to check our title first, make sure we comply with that 25-day notice,
Okay.
that there's nothing else out there.
So are you doing that 25-day notice before you send the the acceleration?
Yes, we are. Or you can do it at the same time if the 20 days to cure have already run.
Okay.
But before you can take a deed in lieu of foreclosure, you want to know those kind of things too. Because let's assume for a moment that this borrower has other liens against the home. Now, here in Texas, we've already talked in other videos, there's only a few kind of liens that can actually attach to a homestead. But if these liens are out there, have been filed, especially an IRS lien, and you take a deed in lieu back, you may very well wind up having those attached to your property, and then you have to deal with them.
Wow.
So if you find that, unfortunately, a deed in lieu may not be an opportunity. You have to go ahead and go on through with the foreclosure. Okay? But what I like to do is I like to provide solutions to borrowers.
Wow.
One of the things I've never found is I've never found a borrower who wants to be foreclosed on. But what it is they act out of ignorance, they act out of fear. They don't know what to do. And so oftentimes if we as an investor can give them options, maybe that option is we can take a deed in lieu. Maybe we can help them sell the property that will get some of their money back or something and prevent the foreclosure, but still work viable for us, for our plan. And every deal is going to be a little bit different as a business decision in that regard. But if we can give our client some options, maybe we can forego the foreclosure, get the house back quicker. Heck, cash for keys.
Right.
Sign a deed in lieu, here's $1,000 to move. You save legal fees, it's well worth it. Time is money also.
Right.
But it's always about being wise and finding that out. And so it doesn't matter whether in this scenario it's a wraparound mortgage or whether it is some type of an assumption or deed of trust to secure performance type transaction that we use. It's the same process. Now, if there is an IRS lien and we foreclose and we as the investor are the purchaser of that property, we have to wait 120 days for the IRS's redemption period to run. That means they have the right to come in and to basically purchase the home for what you have into it.
But that never happens.
Well, it does happen, but it's, in my opinion and what I've seen in my experience, it's been very rare, at least out there. But it can.
It's the government.
It is the government.
They probably don't even respond.
Well, oftentimes they don't. Most of the time they don't, but they could. That's just always one of those little risk factors that you have to consider as you go through and do this. Now, if the property is a non-owner occupied property, again, you have to read your deed of trust. So many circumstances, maybe you sold the house to an investor. Maybe the resident you sold to no longer lives there. They've moved out. Maybe they bought another house. They've leased the house out to somebody else, and it's no longer their homestead. Well, if that's the case, again, you have to read your documents. Doing a transaction right now where, even though that is a situation, we had to give the borrower a 30-day notice. Typically, in a deed of trust, a borrower who is a non-owner occupant waives various notices. And therefore, you could, based on your documents, simply accelerate the loan and post it for foreclosure 21 days prior to the first Tuesday of the month. So you can forego that 20-day notice period. Now, I think it's always a nice thing to do to give them 5 or 10 days to cure in those instances, if possible. But if you're putting a hard deadline...
owner occupied, which is most properties as investors, right?
Well, a lot of times if we're doing that, yeah, it's owner occupied. But I deal with a lot of investors who sell to other investors with these kind of deals. And buyers can move on to other houses. So we have to know a little bit of what we're dealing with to make the right decision. But end of the day, when in doubt, always err on the side of caution. Send that 20-day notice, take care of the issues, don't have to worry about those anything else arising, and move on from there.
Okay, Scott, let's talk about collections and loan servicers. Tell us a little about, what is a loan servicer and why should you use one and how does it work?
Susan, years ago, we never used loan servicers. There wasn't a lot of need for it. I think in the industry today, it's a great tool to have. And I call the loan servicer, of course, our fraud preventer, right? So that if an investor has sold a home to a homeowner and there's an existing mortgage, let the borrower pay that servicer. Servicer will pay the mortgage company first and pay us, the investor, second. It gives the buyer peace of mind that that underlying debt's going to be taken care of.
Okay.
Now, do you have to use a loan servicer on every deal? No. A borrower and a lender can agree to do whatever they want to do.
Right.
I just think it's a wise thing for insertion.
Especially as you get a lot more properties, I would think. One you might be able to handle, but
No, you're exactly right.
multiple.
But I think that's one of the things that they should do and think that way for those reasons. Now, if you have your house is debt free, no, you can service your own loan in that case.
Right.
And there's no way that if this borrower doesn't make a payment and the house is getting foreclosed on for some reason, he can't come in and claim that you did something hokey. The servicer is there to help, be that that buffer
Right.
in those situations a little bit.
So what is the loan servicer's obligation?
Okay, well, let's just go through that a little bit. So, first off, I think everybody needs to understand what their obligations are. And so often investors just don't take the time to read their documents to see what they actually say. What is the monthly payment? When is it due? When is it late? What is the actual late charge? And guys, you can only charge a late charge based upon the principal and interest amount. You cannot charge a late charge on the escrow. Also, here in Texas, the Texas Finance Code governs the maximum you can charge for a late charge, which is 5%. I see a lot of people try to treat a mortgage like a rent, where they try to put a per diem, per day, late charge. I want 5% and $25 a day thereafter. Or they'll use a flat number. I want $200 late fee plus, plus, plus.
Right.
You can't do that. So know what your documents say first and foremost, so you can communicate properly with your borrower and with your loan servicer, and when the case may be, with your attorney. So when you look at a loan servicer, especially in the seller finance industry, I think we need to separate ourselves from traditional mortgages, where we're dealing with A-plus borrowers out there, and our world. Our world is totally different.
Right.
We're not going out getting 3 and 4% interest rates, dealing with A-plus borrowers who pay on time and take care of things. We're dealing with people who are paying 8, 9, 10% interest rates, who oftentimes are late in making payments. They have 1, 2, 3 jobs trying to make ends meet sometimes out there, and things like this.
Okay.
So there's a different mentality, I think, in the owner finance loan servicing world, and I think there's a lot more work to be done sometimes too. And that's where I see there needs to be a marriage. But basically, I think a loan servicer, number one, first collect the payment and distribute them appropriately. Pay any underlying debt first, pay the investor second. Next, if there's escrow being collected, which in most cases there is, and usually if there's an existing lender, make sure that is passed on through to that lender. If not, they're going to hold that in some type of an escrow account on behalf of us as the investor.
Okay.
I think a loan servicer should send out late notices. A payment is due on the 1st, late on the 10th or the 15th. It's not paid. Yeah, they should send out a standardized late notice of some type.
Right.
And in some cases, some servicers want to send out pre-foreclosure notices. Now, I'm not a big fan of that, because I think
Is that the 20-day notice?
that's the 20-day notice to cure in most cases.
Okay.
Because I believe that a borrower is going to pay a whole lot more attention to an attorney's letter than their loan servicer, whom they're paying every month over and over again.
Right.
And I think that probably holds true in most cases out there.
So what will a loan servicer not do or should not do?
Well, I think there's some things that they shouldn't do. First off, most loan servicers don't want to accept partial payments unless they've been put on notice to do that.
Okay.
And in some cases that's great, but they'll usually hold those in suspense in some format. Next, a loan servicer is not there to negotiate out a workout plan. That is our job as the investor to do that.
Okay.
They're just there to collect that payment and distribute it properly. But if there's going to be a workout plan, we as the investor need to set that up properly and make sure everybody is notified. We'll talk about that a little bit more here in a moment. And they really shouldn't be sitting there calling your client all the time.
Right.
I want you to think about this. Look at a rental property and a owner finance property. We talked about the difference already with the owner finance world versus the traditional mortgage world, being a lot more work. Loan servicers collect a very small amount every month to handle these things. $20 to $35 or so.
That's it?
That's it, not a lot.
It was a lot more than that.
What does a property manager collect? Usually it's a 10% of the rental amount. So if you have a $1,000 rental, they collect $100 a month. If you have $2,500, it's $250 a month. And yeah, they're going to be a little more proactive now in that rental collection, but they're getting paid 3, 4, 5 times much more money to do that same thing. So keep that in mind, guys, as you are wondering what your servicer should or should not be doing. And remember, it is our money. It is not the loan servicer's money. The debt, if we have debt on the property, is our debt, our obligation. It's not theirs. No one is going to have, collect your money better than yourself.
Yes.
And so I always recommend that our investors be as proactive as possible out there.
Okay. I know you see in your law firm, you'll have people call you to foreclose and they'll be 3, 4, 5 months behind, and they're with a loan servicer, so they're not paying attention.
Well, the investor, unfortunately, oftentimes treats it as mailbox money. We say that all the time too. And they're not following up on what they need to be following up on. It's not the loan servicer's job to retain in this industry per se, to retain an attorney and foreclose unless they have agreed to do all those things. But what if you as the investor don't want to foreclose, but you'd rather go out and work a deal out for your borrower? That's why you have to be proactive in this industry and get it done. Whether you have 1 loan or 10 loans or 100 loans, take charge of your money. Use the servicer for what they should be there to do, the fraud preventer. But everything else, go after it.
Okay, and you don't want to take partial payments. Why?
Well, I'm okay to collect a partial payment when there's not a default, but they're still going to incur a late charge. But at some point in time, you don't want to do that because you just keep getting this rolling late charge, and they're paying later and later out there. You want to encourage them to pay on time. If you are in a pre-foreclosure mode, let's say that 20-day notice has been sent out, the loan servicer should put on notice not to accept anything but the full payment. Now, usually if we do that, our notice letters tell the borrower that they have to pay the entire amount, not a partial payment, because if they collect a partial payment and they actually transact it, cash it, it will invalidate the foreclosure notices and you need to start over again. So usually they'll hold those in suspense. That's what they should be authorized to do in that regard.
Okay. And now if the loan servicer is sending out these notices and then the 20-day notice, who pays that? The investor or who pays for those
Well,
fees?
that's going to be the borrower because it's their responsibility to pay, and their documents state that that's what they have to do in most instances. And if that has been the case from a servicing perspective, then and the borrower doesn't pay it, and the investor is going to instigate foreclosure proceedings, they're going to pay for that one way or the other, right? All that happens is if the servicer and or their attorney got the ball game rolling a little bit faster, doesn't cost the investor any more money. It's just helping them be a little bit more proactive out there in that regard. Now, if there is a need, the situation's arising out there, and the investor is going to contact their borrower, talk to them about some type of a payment plan, it's fine. But if you do a payment plan, get it in writing. Agree to it, sign it. Let your servicer know what you're doing. If it's a substantial situation, maybe you're changing the day of the month the payment to be due. I did a loan just like the other day, by the way, where the gentleman was always late in making payments because of how his payments came in from his job. And he kept incurring a late fee. We changed the payment date. So it would accommodate that so he won't be hit with all these late charges. The lender didn't have to do that, but it was the right thing to do to help. Solves the problem in that instance. And sometimes you've got to do a loan modification to restructure transactions if there are more difficult things to be done out there based on various things. Maybe you're going to change the interest rate a little bit. Instead of going through a foreclosure, if you can just reduce things a little bit, maybe it becomes a win-win for everybody.
But those are always decisions and conversations that go from the lender to the buyer.
They should
Never from the servicer. You never want them.
Well, a loan servicer has no idea what we as the investor want. They don't know what the servicer wants or needs. The servicer's position may be, or the investor's position may be, I'm done, take the house back. Mm-hmm. Or it may be, no, I don't want to deal with this. And I've got one of those right now where they really hope that the borrower pays, can restructure a loan somehow. They don't want to foreclose. Now, we're still moving forward with the process, but a servicer has no idea what the needs are for every investor out there, or which may change from time to time.
Right.
And so we as the investor have to take the bull by the horns and make these decisions. Mm-hmm. And guys, whether you want to do it or not, if you're in this industry and business, you have to step up to the plate and do it. And if not, you can't do it, contact your attorney, contact us. That's why we're here. And sometimes a loan servicer may do those things for you if they're empowered, or they may do it for a fee. That will be between you and your loan servicer to discuss those items. Okay. But they need to take the time and be proactive as they go through this.
Okay. So if you, and I know you handle a lot of foreclosures, can you foreclose all over Texas, or are you just in DFW?
No, we handle foreclosures all over Texas, and we foreclose everywhere from, although we're in Dallas-Fort Worth, which is easy to do, we do, of course, the 5-6 county area here. Okay. We regularly do foreclosures in Austin, San Antonio, Houston, Corpus Christi. I haven't done the Valley in a very long time. I've never done one in El Paso, but we can. Okay. We've done them in East Texas, as I said, as well.
And what can an investor expect as an average of what that would cost them if they're going to go into a foreclosure?
We're a little bit more of a unique law firm than other firms are. Mm-hmm. I've seen foreclosure fees anywhere from $1,500 to as high as $4,000. Wow. Based on various transactions out there. Probably averaging $1,750 or so seems to be the norm. Okay. Sometimes just a little bit higher. Because we have multiple businesses and whatnot we do, and we're trying to provide a service to our investor industry, and we don't represent these big banks. We represent our investor communities around Texas. Right. Typically, if it's local, it's going to be about $1,250. But we got to also do that title search. Mm-hmm. And you got recording fees. Okay. If it's, we call it out of our county, there might be a $100 additional fee added to that. Maybe $200 if certain things are out there, but we try to keep that cost down as much as possible for their benefit.
Okay, Scott, let's talk about some of the mistakes that investors make. And you see mistakes all day long. This could be a 2-hour question with all the mistakes I hear you tell me about. So let's talk about one of the more common ones, using the wrong contracts.
Yeah. And these are some things that just have happened literally this week. Mm-hmm. So coming back up, where investors, they will prepare a contract. In their mind, they're going to do a seller finance, but they write an all-cash contract. And they sign it. Mm. Well, they've bound themselves now to an all-cash deal with their buyer, even though they intended to do something differently. Mm. Instead of getting the thing done correctly and the right disclosures, they kind of jumped the gun a little bit. Mm.
At that point, can they cancel that contract and void it out and say, I made a mistake, and get a new contract?
Well, you would hope they could do that, and everybody would agree to it. Okay. I see transactions where they're intending to do some type of instead of an immediate transfer of title, mm-hmm. They may want to do either a short-term lease option, and if it's a non-owner occupied transaction, a contract for deed. But they've already executed a full contract for doing a full seller finance transaction. So then they go back and have to amend their transaction so long as the parties agree to it, because the buyer could hold their feet to the fire if they wanted to. So you see those kind of things that happen. And so the key with that is I always say this out there, know before you go.
Right.
Before you sign, make sure you have the right stuff put together so you don't obligate yourself to do something you never intended to do.
Right. And if you're, maybe if you're a newbie in the business, you know, to avoid those mistakes, you might want to hire a note pro that you could help structure the deal for them and help fill out the contract.
Well, either a note pro or an attorney until you get comfortable doing the transactions properly.
Okay.
You know, one of the other things that we've seen this week, Susan, has been where and by the way, this has been around for a long time, it's where investors want to sell their home in some format, go through a closing, they don't record the transaction. They don't file the deed. They don't file the deed of trust. And of course what happens is, well, let's back up. They're doing that because they think that by not recording their documents, that it won't affect the due on sale, is what you usually see out there. But this opens a whole other can of worms. Now, here in Texas, there is no legal obligation for a third party to record a deed after it's been executed. Once you sign that document, it's been sold.
Okay.
But what could happen? Now, if it closes at a law firm or in a title office, we normally have a 30-day rule where we have to record those.
Okay.
So hopefully if it's done the right way, it's going to be taken care of.
But if it closes through a title company, it doesn't have to be recorded?
It will be.
Okay.
We have an obligation at that time to make sure those are recorded out there.
Okay.
And all recordation does is put the world on notice in those instances. But I see so many investors who, they'll close the deal, it closed outside of a law firm, it closed outside of a title office, and they're holding it back. But think of what could happen. One, the investor could sell it to somebody else. And we've seen that happen before. You don't like it, but it can.
Okay, Scott, another mistake investors make that we see a lot is they don't record the mortgage.
Yeah. And this has been on for a long time.
Right.
So an investor will close a transaction, but they don't record the deed or their mortgage because they're afraid of due on sale. They think that if I do that, we're going to get a due on sale violation and the mortgage company's going to call the loan due. And we all understand what those risks are a little bit.
Right.
But the risks of not doing that are even bigger. Now, normally, if a transaction is closed in a law firm or in a title company, we kind of have what's called the 30-day rule where we're required to record those within 30 days of closing.
Okay.
And we do.
Okay.
But if an investor closes a transaction outside of that, they do that proverbial kitchen tabletop closing, they hold it back. But my gosh, think of what could happen. So the investor sells the house to somebody else who then goes down and records the document. Well, here in Texas, we're a first-in-time state. Whoever gets to the courthouse first wins. Other states may have different rules and regulations about that, but not here in Texas.
Wow.
So that could be terrible, right?
That's horrible.
And by the way, that happens. In fact, we saw that happen just recently down in San Antonio. Other things.
So wait, stop for a second. I got to ask you this. So if that happens, what happens to the people that bought the house that are in the house?
Well, they could be evicted. They could sue the seller, who has probably run off with their money and has nothing left. And they could actually lose their home. So again, you want an informed seller who knows how to do things the right way also.
Wow.
It's just, there's just things that people do that just don't make any sense, and you understand why.
Right.
But, I mean, again, real life scenario here, where an investor did that on a closing 10 years ago. Think about this. What liens, IRS liens, judgment liens, could have been placed against the seller in that time frame that would attach to that property, which means the person who bought it or thought they bought it, that those could be attached to their home ahead of their mortgage. And they have to contend with that because the seller might be gone. That's not good.
Wow.
Think about if you don't convey the property to the borrower, they don't get a chance to get a homestead exemption on their home. That costs them money. What if they're over 65, over 70, or have other scenarios ongoing that allow them additional exemptions that they can't take? We have a lawsuit that I'm aware of right now where this occurred, and the investor never sent a 1098 to the homeowner, so they could never write off their interest. 10 years of that. Add that up.
Well, you'd think they would have asked after the first year.
Homeowners don't know sometimes.
Wow.
They don't know what they don't know. They weren't able to get a tax write-off. They didn't know what they were paying, even though they were paying escrow. They weren't allowed to get the insurance they wanted. And when you take interest deductions, you take property tax deductions, the fact that they lost all of these exemptions that they could have had years and years ago that cost tens of thousands of dollars of additional monies in taxes. This investor is going to have a huge, suit filed against them for this.
Right.
And it's just wrong. So guys, do the things the right way. Record your transaction in your documents. It's okay.
But you're telling them to record it. Shouldn't the title company and the attorney record it?
If you're closing title and you're closing the law firm, they will record it.
Okay. But if you're doing it yourself?
Well, you should do it as well. Hopefully you're not doing it.
I didn't know you could close it yourself.
You can pretty much do anything yourself. It's just
I didn't know that. I thought you had to.
Just not advised.
Okay. Okay, well, tell me about, and this is a mistake, and you and I were in court just the other day about this, about trying to use a lease option.
Yep. Well, again, just like not recording documents, trying to get around doing sale, a lot of investors who, again, who simply haven't been trained properly think you can do a lease option long term for the same thing. And what they don't realize is that they had just talked to an attorney, spent a little bit of money up front.
Right.
They could avert huge issues.
Right.
In this one scenario where there was a 5 years lease option, and it was intended to be a subject to transaction with a balloon on the end. They had nothing was done correctly in this transaction. Absolutely nothing. I won't go into all the details. But had they done a proper subject to transaction, gone to an attorney to construct it correctly, the investor could have now saved tens of thousands of dollars in the non-payments that have occurred, in the attorney fees, and the bankruptcy fees, on, by just having done things the right way the first time. I see so many investors, though, who try to save a buck. And at the end of the day, as they say, you step over $1 to save a dime, right?
Right.
So sometimes it's worth that little bit more money to take care of things the right way.
Okay. That's great. Well, reach out to us at info@theownerfinancenetwork.com and let us know if you have any Ask the Attorney questions that we could include in future segments.
Thanks, Susan.
Thank you.
Hey guys, if you like this video and want more free information on owner financing, please subscribe to our channel and hit the notification bell to be notified when we post. Don't forget to like this post and ask me any questions on owner financing below. When you're ready to take the next step, head over to theownerfinancenetwork.com and check out our in-depth course on owner financing.